Good afternoon, everyone. We're joined here today by Judge John O'Connor, who's going to speak to us about the operation of the Assisted Decision-Making Act in the Dublin Circuit Court. You're very welcome, Judge John O'Connor.
Thank you, Greg.
Before we get started, could you tell us a little bit about yourself, how you got into law and how you became a judge of the Circuit Court?
Well, I'm a lawyer for a very long time. I'm 45 years plus. I was a solicitor for many years. I practiced in the west of Ireland for 8 years, and then I practiced in Dublin for about 30 years. I became a judge of the District Court, where I specialised in juvenile justice, and then I was appointed to the Circuit Court in February 2019. And I got interested in this area of law really from practice as much as anything else, and then I got an academic interest into it, so I did my lit in Trinity on the area of capacity law.
And can you describe the work that you've done since the commencement of the Act in terms of the ADM Act itself? Like what have you done itself?
Well, when the Act came in, it was a new Act for all of us, and the Circuit Court was the court, or is the court, in fact, for the purposes of the Act, as opposed to the High Court. So it was a brand new area of law. And the President Ryan, asked me would I mind leading in relation to it. And so we developed a protocol as to how the cases should be run, really. That's how it all happened, Chair.
And how do you interact with other judges? Do you come together as a group? Do you have training together? How does that work?
Yeah, we have training sessions. We have continuing legal education programs. We have seminars, and we do meet. And we're a small jurisdiction. We've only 46 judges, so we all know each other quite well. Now, some judges are dealing with multi-complex areas of law between crime, family law and civil law. I tend to only do civil law for the last 5 years, but we talk to each other all the time. Yeah.
And do all of those 45 judges hear ADM cases?
Not all, but most of them would.
Okay. Can you then, we're going to go on to talk about how the Act works in practice. So can you tell us how you ensure the voice of the person is heard? What challenges do you encounter in ensuring that the voice of the person is heard?
Well, the whole central part of this Act is that it's putting the relevant person centre. Compared to, we say, the Wards of Courts Act, which would have been very much an act for planning for the future, even for future inheritances. This Act is concentrating on the person themselves. And central to that is Section 139 in the Act, which says that the relevant person shall be in court unless the court dispenses with it. Now, that's really important because it's about that person, and it doesn't matter if the person has a disability or, in fact, they're not even aware of what's going on. The judge needs to be aware because it's about them. We have a Latin phrase, audi autem partem, no one should be condemned without being heard. And it also gives context to the case, and it respects their rights. So it's very important, insofar as we can, to have the voice of the person. Now, we are quite open to how that is done. For example, some people come to court, but if they can't, we do it with video link, maybe to the hospital or the nursing home, as the case may be.
And is there anything that the HSE and health services can do more to support the person to be able to engage in that process?
Yes, I think so, because a lot of this is, cognitivity in relation to dealing with a person who may have, language issues, may not be able to understand matters. So I think they need to be very relaxed. They need to be in a situation, and the Wi-Fi needs to work.
Yes, indeed. Yeah. And can you describe the role of the lawyer for the relevant person and for the applicant? What's the distinction?
The reason why we have a lawyer for the relevant person as such is that we have case law, which, right up to the Supreme Court, which basically states that the relevant person, even if they don't have capacity, have rights. They have the full rights of any human being, and their rights need to be respected. In this regard, the government have funded the Legal Aid Board. The Legal Aid Board do provide a service which is free at the moment. So for the relevant person, so there's really no excuse. Now, they don't have to use the Legal Aid Board. They can use their own solicitor. But it does ensure that their rights are respected. Yeah.
And is a lawyer required in every case for the relevant person?
Certainly we would try and insist in nearly every case. I mean, there may be exceptional cases, but it would be very rare that we would not have a lawyer for the relevant person. It's easier in Dublin because we have a solicitor who's in court all the time, and it was available to act for the relevant person. So it's not really an issue in Dublin as such.
What happens where they can't get instruction from the relevant person?
Well, that's quite common, that you can't get instructions. And, I've done a case in relation to all of that. But that doesn't mean that their rights are not respected. I mean, what the lawyer needs to ensure that there's no conflicts of interest, that the court is apprised of any issues that might affect the decision in relation to it. And here, for example, there could be issues in relation to financial matters that need to be investigated. And usually what happens in relation to those cases, the lawyers preparing the report will schedule the assets, the liabilities, and give a sort of an overall view of the issues to the judge rather than just saying what the instructions are.
And are there many applications without lawyers? Have you seen many applications where there's no lawyer involved?
This is for the applicant as opposed to the relevant person.
Yeah.
About 1/3 are without a lawyer, 2/3 are with lawyers.
Okay.
It's not essential to have a lawyer. More complex cases tend to have lawyers, but it's not essential. We try and do this not adversarial. We try to do it inquisitorial, so we do try and assist. The court service try and assist, and we try and assist as judges to make sure that the applicant can proceed with their application if at all possible.
Okay. What about, can you talk to us a bit about independent advocacy? Is independent advocacy required in every case?
Well, independent advocacy is simply reproducing the voice of the person. They're not acting as lawyers. But what happens is, as we have discussed, a lot of the relevant persons have communication difficulties, and they may have serious capacity issues. But what we're trying to get as will and preferences, which is the central thing in the Act itself, and experienced advocates who can reproduce the voice insofar as possible. Now, that's all they're doing. They're just reproducing the voice so that the court can get a view of what that person really wants themselves. As to whether it's necessary in every case, if we have the relevant person in court or online, and the person is able to communicate to us, it's not necessary as such, but each case is individual.
And do you wait until how would you know that in advance?
Well, people are quite good now in relation to doing it, particularly in relation to elderly cases, where particularly we might be a dementia or Alzheimer's cases. You have advocates, and people tend to get the advocate's report in advance. But if we don't, we have to adjourn the case, basically.
We talked about lay litigants. Is it still the case? I know in the beginning, at the very start, there was a significant number of lay litigants. Does that remain the case as people representing themselves?
It's not hugely different. It was about 40% when I started, and I'm talking about the Dublin circuit. But the Dublin circuit would deal with probably 45% of all the cases in the country. But at the beginning, it was around 40% were lay litigants, and the applicants, in other words. It's now about 35%, so it hasn't changed.
And is that replicated outside of Dublin as well?
Yeah, although you could say that when it's outside Dublin, in some areas it's not the same. Some areas there might be more lawyers involved.
Can you talk us through some of the complexities of the cases that you see, just a kind of a sample of the kinds of issues that you see coming through the courts?
Well, 70% of the cases are involving the Fair Deal scheme and the ancillary state support. I mean, obviously some cases they don't need the Fair Deal scheme, but they need the ancillary state support. But it's usually not just that. They require other matters. They have a pension, they have a house. What's going to happen with the house? Is it going to be let out? Is somebody going to live in it? Who's going to look after the house? In relation to the pension, in relation to the bank accounts. So they're the kind of general sort of about 70% of the cases. The other 30% cases tend to be more complex, and they can involve quite a lot of assets in some cases, or there might be quite a lot of needs, personal care needs or medical care needs in relation to it.
And in terms of the 30%, are they still in relation to older people, or is that across the lifespan? Over 18 though?
Over 18, yeah. Probably more concentrated on younger adults, particularly with the catastrophic injury type cases. Sometimes it's older people, but more on the younger people. Yeah.
Can you describe how you manage your list in Dublin? How does that work?
Well, we have 2 days a week. We've Wednesday and Friday. So we would do somewhere in those 2 days, we deal with maybe 30 to 40 cases in the week. We divide it between two judges. I deal with a Wednesday and another judge deals on a Friday in relation to cases. So we have the ex-parte applications, and then we have the new applications, and then we have the renewals, and then the cases that come from the wardship down from the High Court that come in. But generally speaking, the office is quite good. So people, when they come along, the paperwork is reasonably quite good. I have a judicial assistant who helps me then check the paperwork before I deal with it on the day. So we go through the affidavits, we go through the timescales involved. I look at the capacity reports, so people are not delayed too much in relation to it. Otherwise, you'd never get through the cases.
And approximately, and obviously complex cases are longer, but approximately how long would a case take?
Well, I suppose if you say 15 cases in a day and we start at 10 o'clock, we try to get maybe 5 or 6 cases done in an hour. But that's for the very easy cases to get through. The complex cases obviously will take longer. And we've had cases that have lasted a day or 2 days. They have to be specially fixed.
Yeah, okay. And in terms of outside of Dublin then, are extrajudicial resources appointed to deal with the ADM cases outside of Dublin?
Yes, the President has allocated additional resources to that. Now, we did get 6 additional judges on the first tranche of the Judicial Planning Working Group. We're waiting for another 6 judges, which we could deal with, and it would help enormously. It does put strain also on the court staff, but the President has allocated that judges will do additional work in relation to this, and we do have judges who actually exclusively deal with this work as well. Yeah.
So can you describe what you're looking for in a capacity statement?
What we're looking for in a capacity statement is a functional assessment of the person. So, a statement that says that somebody lacks capacity without justifying that statement is not worth anything. Ultimately, it's the fact of a judicial decision to decide whether somebody doesn't have capacity or not. And we need as much information as we can in relation to that. Now, there are screening tests like the mini mental test, but they're only screening tests. You do need to do a functional assessment, and it's issue specific and time specific. So some people are good in the morning, some people are good in the afternoon. Some people are able to make reasonable, not complex type questions. Like, for example, they might be able to buy a newspaper, they might be able to decide what they want on television, they might be able to decide what they want for their dinner, but they mightn't be able to do a major financial transaction. So that's the sort of thing we need when a doctor is doing, or a nurse or a social worker is doing a report, is to be issue specific in relation to it. And there are templates on how to do that as well. And
are you seeing, so the Act provides that there's doctors and nurses and midwives, occupational therapists, speech and language therapists and social workers can do the assessments. Are you seeing much assessments beyond doctors coming through your court?
Well, I've done, altogether we've done about 3,000 cases since it started as a circuit court, and I've done about 600 of those, and I've yet to see a midwife's report. But so the majority are doctors, but we have seen quite a few with social workers. We've seen also with speech and language therapists in conjunction with social workers, and that's perfectly acceptable in relation to it. We're not stating that people can't do it. The only thing is, as long as they don't have a conflict of interest,
Okay. And are you seeing, has the quality improved since the Act has commenced?
Yes, is the short answer to that.
Okay. In what way?
Well, I think helpfully Professor Sean O'Keefe, who's a consultant geriatrician in Galway, has prepared a template for doctors to use. But it's rare that you would get a report from a consultant, particularly a consultant geriatrician or a consultant psychiatrist, that wouldn't comply with what's required. Sometimes doctors and GPs who are very busy, and you can understand that, the reports are very short and really are not issue specific, and they're very general in nature. Social workers tend to do very good reports, actually. They're quite detailed, and nurses and speech and language therapists who sometimes feed into that are very good as well.
Great. And what about, so under the Act, there's an ability to do look for a report under Section 50 of the Act. It's a specialised report. Do you seek reports? Do you see that coming through at all?
It's something that we have. I've threatened it a few times to get specialist reports in relation to it, but this is inquisitorial rather than adversarial. So what that basically means is I'm trying to help people to get through the reports. If we can't get a particular specialist report, we can make an order under Section 50 asking for that. But I prefer to try and get cooperation if I can of that.
Okay. So the Act states that least restrictive measures must be considered before an application for a DMRO is commenced. So can you describe how you're, I suppose, assessing that least restrictive measures have been considered?
Well, what we want to see is it required in the first place at all? And we've had a number of cases, not a huge amount, but cases where it was clear that it wasn't required. As you know, this is a tiered structure, this Act, so if people may need a little bit of assistance, say they had a stroke or whatever, that's an assisted decision-making agreement. If, for example, they don't have capacity, but they had somebody who was helping them and would have capacity if that person helped them, that's a co-decision-making agreement. That can all be done without the court. And then the court is the ultimate is substitute decision-making. But there are cases where I have come across where an assisted decision-making agreement was required. It was exactly somebody who had a stroke, they had a speech impairment, but otherwise they were fine. Co-decision is not that common, but it does happen. I've had about 9 or 10 cases in relation to that. But most of those co-decision-making agreements would be done prior to coming to court. But what I do in those cases, I adjourn the application to have the co-decision-making agreement entered into. Now, there are cases where somebody does could enter a co-decision-making agreement, but they have no family member to help them in relation to that. Then you have to go to the panel. And the problem with that is that the panel don't do co-decision-making agreements. But fortunately, there's a provision in the Act, Section 41.3, which says that if somebody in that situation, we put into the court order that any decision is to be made in conjunction with the relevant person.
Great. Okay. What happens if you get an application for a DMR that lacks specificity?
Well, I suppose the short thing is we adjourn it, but we look at what people want. I mean, as I say, it's quite inquisitorial. So if the applicant is in court, I ask them a lot of questions. What do they really want in relation to it? Quite often it's the fair deal scheme and the ancillary state support. But if it's something more complex than that, we might have to adjourn it. We might have to make an order for part of it and then adjourn the rest of it.
And would that happen? How frequent would it be, not like unspecific?
I don't have the numbers in relation to it, but it happens frequently enough. Yeah.
What happens if an applicant comes to court seeking a DMRO but doesn't have all the decisions required? Say, for example, the person has come looking for the ancillary state support, but you can see it's much more than the ancillary state support. What would happen in that case?
Well, we ask them a lot of questions, and then we say, well, do they have a bank account? Do they have a credit union account? Do they have a pension? So we ask them a lot of questions, and we try and cover some of it if we can at all. But if it's quite complex, we might have to adjourn a portion of it. Quite often the fair deal scheme is the most urgent matter because they're probably on transitional payment, and we might have to make an order for that and then deal with the rest at another date. But we don't have any delays in Dublin circuit because we have the courts twice a week, and once people have their paperwork done, we can process it as quickly as we can. Yeah.
Okay. And if say, for example, would that be an interim order that you would be granting, or is that, how would that work?
Interim orders are really emergency type orders. So somebody, for example, in a hospital situation and they need an emergency operation, that would be an interim, classic example of an interim order. We have used it very occasionally where somebody has all the paperwork done and it seems to be fine, but the transition payment has run out and there's one little thing left. For example, then the affidavit might be 20 days as opposed to 21 days. We might give an interim order there. But we try and avoid it as possible because interim orders are not reviewed by the DSS. They're only for 3 months. They're not really very satisfactory even from the Fair Deal Scheme, because Fair Deal Scheme is a 3-year contract. But it's useful to have it there, particularly for emergency orders.
Okay. And then just kind of allied to that then, have you had many applications, people seeking to vary or vacate an order, to change an order?
Well, not so much vacating the order, they tend to let them run out, and sometimes, unfortunately, people die, and they do come in with the death certificate and an affidavit, and we close the file in relation to it. To vary it is common enough, and one of the most common ones would be, for example, somebody has a house and they've gone into a nursing home, and then maybe after a few months they might want to sell the house. That's usually a new order, actually, in relation to it, but we use the information that we already have. So they might have to bring another motion, but we would help them with it. Sometimes sometimes an order can be varied because there was either an error or something minor that needs to be rectified. Yeah.
Okay. Are family members usually appointed as DMRs?
That's a very general kind of statement, but and I suppose to give you a very general statistic, it's about 80%. 20% would be a non. Usually in the 20% that is non-family, it would be mainly for financial matters, but it can also be for issues such as, personal care decisions or medical care decisions. Okay,
so can you give us an example then? Like, what circumstances would you not appoint a family member then?
Usually financial matters would be because they're quite complex. Somebody has a lot of money involved. They don't have the experience to deal with that, so they need somebody who has that experience. Sometimes in relation to personal care decisions, there could be conflicts. Somebody's living in the house and or they mightn't be able to do it, it's a reality. In relation to medical care decisions, there's a conflict between the family and the medical care staff. And if that can't be resolved, we try and see if it's resolved. But if it can't be resolved, it may be necessary in the interest of the relevant person, because all we're thinking of in these cases is the relevant person. They're a centre stage.
How does the request to go to the DSS to seek a nomination, how does that work then?
What happens is if we decide for a panel member for part of it or all of it, we send a request to the DSS and they give back 2 names. They have a panel. If the areas are quite complex, we might say that there's a particular complex area of law or complex personal matters in relation to that, so that they can maybe send people who are appropriate in relation to it. But the DSS panel have already been they've been trained and they've been interviewed and vetted by the DSS, so we don't second guess that. So we get 2 names and we pick one, but it is a court order to make which one.
And have you mentioned there that sometimes you might have a family member for certain orders and a panel member for certain orders. How does that pan out?
It often works quite well. I mean, particularly personal care, somebody's, and we could even have, although we don't always encourage it, but maybe somebody can do personal care decisions and somebody else can do the financial matters, another family member. For more often than not, it would be a panel member in very complex financial matters that would look after it. Or if there's a conflict or somebody's living abroad and they can't really deal with some of the issues, then that can happen.
One of the requirements under the Act is that certain categories of people have to apply to the court for permission, and it's called an ex-parte application. Do you think that's useful?
It is useful. Whether it's essential or not, I don't know. I mean, about 40% of the cases that I deal with are the HSE. They tend to be quite straightforward in relation to it. Some judges say that they're very useful for somebody coming into court to explain to them what is required for the main application, so that they don't have any delays in relation to it. It doesn't take very much time, and we try and help people along in relation to it. It does vet out unmeritorious claims. You might have somebody who claims that they have a right to do that, and then you say, how do they have a right to take this application?
And would you see the ex-parte, like how many would you see that would stop at that stage?
Not too many, but it can happen, yeah. And yep. You will also highlight if there's conflicts. Sometimes you might have one person applying, you might have the HSE applying, and you might have another family member applying.
Yes. How much time does it normally take to get a full hearing after the ex-parte stage?
Well, you can get it straight away, provided you have your paperwork done. I suppose in reality it's going to be a minimum of a month because you have to serve the notice, which is 21 days in relation to it. You do have to have the advocate's report. Now, sometimes people at this stage will have applied for the advocate's report already. You do have to have your capacity report. You might well have a comprehensive capacity report at the interim stage. And then you need also your lawyer, independent lawyer, for the relevant person's report.
And you said earlier that if the person is able to represent themselves and go into court and speak to the judge or speak online, that the advocacy report isn't always necessary.
No, it's not a statutory requirement.
Yeah.
So the statutory requirement is that the relevant person shall be in court unless we dispense with it. And how we dispense with it, if the person is not able to attend court, is we ask for an advocate's report. But if the person is in court, and we've had even cases where, not very many, but we've had a few cases where the applicant is actually the relevant person. Mm-hmm. They're very vulnerable and they have a reasonable amount of capacity, but not for certain areas, and they have quite an insight in relation to it. An advocate's report helps and assists. It's only the voice in relation to the relevant person, but it's not a statutory requirement.
Right, okay. Can you talk to us about the in-camera rule? Well, what is it and how does it operate in practice in your court?
Okay, in-camera basically means in private. So to protect the integrity of the person themselves, a bit like in family law cases, the cases are in private. Now, it doesn't stop, the press can report on cases, but the person's name has to be redacted, and privacy is important in relation to that. We don't actually have very many requests for the press to attend. It doesn't really cause much of a problem in practice. Where it might cause an issue is where people who are not party to the application might ask or to come into court, and we obviously have to make a decision as to whether they can or not.
Can you explain circumstances where a person might want to make an appeal or seek a judicial review of a decision? So when might that arise?
Well, appeal is usually on a point of law. In fact, it is on a point of law. So that would only arise if, for example, you felt that the judge's decision wasn't right in law. It's rare enough it happens. Judicial review can happen in any case. That's simply to do with whether the procedure was fair or not. Because the nature of how we deal with cases, it tends not to be very common.
Okay. And can you talk to me about, you have 3 written decisions. Can you say a little bit about each of those decisions? And I suppose also, is it normal for decisions to be written in the circuit court as well?
Well, what happens is in the superior courts, particularly the High Court or Court of Appeal, Supreme Court, what happens there is their cases are binding on a court. Our cases are not necessarily binding, but they are useful, first of all, to give visibility to what's happening in the courts, and it does give guidance to both people attending court, practitioners involved. So I have done some written judgments in relation to it. I suppose the other thing is that the nature of our court, 46 judges for a population of 5.5 million, to put into context, the 600 circuit court judges in England for 50 million. We don't have time to be doing too many written judgments. We couldn't get through our list. But I have done some of them, and I suppose I can just talk to you about a few of them if you like. The first one is Joan Doe. She was a lovely lady with a lovely family, but there were issues in relation to this as to conflicts of interest and perhaps a misunderstanding of what was required from both families, and the family were very good about saying what her will and preferences were, but that was a moment in time. Unfortunately, her situation had deteriorated quite a bit, so there was an issue there that it was useful to have them as advocates but not as decision makers, and I think that was the problem that I had to deal with in relation to that. There was also conflicts of interest, but the one thing I was very clear in that is to make sure that the family had full access, because there was a very good loving relationship between in the family in that regard.
And in that case, what was the outcome in that case?
In that case, was appointed independent persons from the panel to deal with the situation. What was very useful in that case, I suppose, for doctors is to see how the capacity report is required. Now, there wasn't an issue over capacity in the case. Both family and the doctors agreed that our capacity had diminished quite significantly in relation to it. And we had a very good advocate who actually was a lawyer, but she was only acting as an advocate in the sense of reproducing the voice, and it was quite helpful to the court and how it was done. The litigation itself was quite adversarial, but ultimately it was resolved with the decision, and I'm not sure everyone was happy with it, but at least it was, hopefully it was a fair outcome. Yeah.
Super. Okay.
Then another case I dealt with was, it was a case of the matter of JD, and that was litigation capacity. And it was an interesting case in this sense that the lawyers, when the relevant person first instructed them, he or she did have capacity, but during the course of the litigation lost capacity. And we had to decide, because it was a real difficulty that if the person didn't have a decision maker, they would lose the benefit of a very good settlement. And one of the things I said in that report was that in analysing medical evidence, medical reports that are based on assumptions without justifying that assumption will be treated with great caution by the court and may be rejected as an inadequate assessment. It's important that a doctor or other expert given the report to assess the person's capacity to litigate is based on a functional report.
So the outcome of that case then, what happened?
What happened in that case, it was a very limited for 6 months. So it was an independent person, a lawyer was appointed for 6 months, specifically just to deal with that settlement and nothing else.
Okay.
The other next case was a case, it was a case of CD and EW, and the property was in joint names. And what happened was, that was the application actually, was the property was to be in joint names, but in fact, the property was in the name of the relevant person, and the family wanted to put it into the joint names of the spouses. And there was a loving relationship and all the rest, and they said that there was a will there that the person was going to get, and they wanted to do it for estate planning and matters like that. But that's not the criteria that we use, because we have to use a least restrictive approach in how we deal with it. And, I give some guidance in that, how we deal with capacity. And also I give guidance on how lawyers should deal with the matters. For example, so the duty of a lawyer acting for a person who lacks capacity, it's not confined solely to taking instructions. And I also stated that, that it's important to acknowledge that a person's capacity can vary from day to day, depending on the issues. And communication difficulties by itself is not an indication of lack of capacity. And even where instructions cannot be obtained, the lawyer should investigate by, for example, cross-examination of a witness or advising the courts of the rights of the relevant person.
So again, in that case, what was the ultimate outcome?
In that case, I refused the application because it wasn't necessary for the relevant person.
Well, what is the trigger for you to write up then? What in those cases, like what is the kind of consistent thing that determines whether you're going to write it up or not?
Well, I wanted to give visibility to how the court operates. So the cases do give an insight on how we operate. So they're broader than just the actual decisions that were made there in regards to it. I know Judge Shannon has also done a leading case in relation to family law, in relation to marriage. And of course, that's important to note that capacity varies, capacity for sexual relations, capacity for marriage, capacity for financial relations is somewhat different. There's not a one for all system,
And are we likely to see further decisions written up?
I'm sure.
Okay. So I suppose my final question then is, how do you see this area of law developing as the Act becomes more established?
Well, we have an ageing population, and that's a big factor. and people are getting more used to the Act. It's a worldwide phenomenon. I mean, this is part of the United Nations Convention on the Rights of Persons with Disabilities. So even countries that are not in our system, like France and all those, they're struggling to deal with this concept. But we're all obviously going to have to upskill in relation to it all going forward. I think there probably will, but it's not for a judge to tell the Oireachtas what to do. But there's probably some amendments that could be very helpful. Perhaps, appointing a public guardian, but that's a matter for the Oireachtas.
Thank you. And thank you very much for your time this afternoon. I really appreciate it. And I think our listeners will greatly appreciate having had the insights from inside the court in the Dublin Circuit Court. Thank you very much.
Thank you, Caoimhe.